Three, two, one, start. When the time punishment order passed by district magistrate and municipal body having been restored, he had lost all authority over municipal body after restoration of municipality powers has to be exercised by municipal commissioner in terms of act and rules. Mere concession is not enough if the law does not permit, so district magistrate ought to have transferred the file to the municipality and should not have proceeded in the matter. Further, he cannot be said to be the disciplinary authority under the statute who can impose punishment, since he did not have authority and power to exercise on the municipal corporation employees. Punishment order quashed municipal commissioner directed to appoint fresh inquiry officer and proceed afresh. Full stop. Departmental proceedings allegation of denial of principles of natural justice. No response given to show cause issued to delinquent. Became aware when published in newspaper. Made correspondence through lawyer with the inquiry officer requesting not to proceed. Matter rightly treated as of non-cooperation. No denial of natural justice. Full stop. Question of issuance of second show cause may arise when disciplinary authority in its wisdom decides to impose punishment after finding of guilt is recorded in inquiry held against a delinquent on the first count, but when order of punishment is passed on the direction of the court, it is not required. Full stop. The amount of evidence to be brought on record will depend upon the prosecution. Instantly, while the prosecutor before the criminal court felt it not necessary to have the officer who was abused and heckled by the delinquent as a witness before the criminal court. The prosecutor before the inquiry officer tell that his evidence is necessary. Therefore, while the disciplinary authority had the advantage of his defense before him, the criminal court which acquitted him did not have its order of dismissal by disciplinary authority upheld. Full stop. A senior police officer heckled in public view by his junior criminal proceeding ended in acquittal as charge not proved, but in the departmental proceeding the charge held to be proved on the basis of materials on record. The outcome of any proceeding will depend upon the quality of evidence placed by the prosecution. The evidence presented before the disciplinary authority was not before the criminal court. Materials available in the departmental proceeding were sufficient to prove the charge order of dismissal upheld. Full stop. Charges alleged to have been proved on the basis of the letter admitting charges by the petitioner. Letter does not show the acceptance of the charge. Impugned order of punishment held to be without any materials and quashed. Liberty given to proceed afresh with the departmental proceeding. Full stop. Every delinquent or an accused has to be granted fullest opportunity to explain his conduct, and nothing ought to be done by any authority to rush to a conclusion declaring a person guilty. Full stop. It is not the quality of the evidence that matters. What matters is the manner and mode in which inquiry is held and conducted before imposing departmental punishment stop.